My name is Vince Rubino, and I would like to explain Chapter 7 bankruptcy cases. This is going to be a long video, so if I get a little tongue-tied, if you don't mind, I'm just going to plow on through. Chapter 7 can be used by companies, individuals, or married couples to eliminate debt. When a company files Chapter 7, its assets are sold and the money is given to its creditors. People like you and me, however, are permitted to protect certain assets under Chapter 7, utilizing dollar amounts called exemptions to safeguard cars, furniture, bank accounts, retirement savings, and equity in our homes. Even your dog can be protected in bankruptcy. As you might expect, however, there are limits to how much you can protect, and if you own $1 million house or a yacht, chances are Chapter 7 bankruptcy isn't for you. Properly utilizing the exemptions allowed by law can be the trickiest part of a Chapter 7 case, and is something you should discuss in detail with your attorney. Let's talk about the benefits of Chapter 7. For those who qualify, a Chapter 7 bankruptcy can be used to eliminate credit card debt, medical bills, personal loans, utility bills, repossessed cars, and mortgage foreclosures. Debts owed to or guaranteed by the government, such as tax and student loans, are ordinarily much more difficult to eliminate in bankruptcy. If you think about it, the government made the rules and naturally thought, hey, let's make it difficult for people to get rid of debts they owe us. That being said, there are circumstances where older income tax debts can be eliminated, and I have had clients who are able to erase hundreds of thousands of dollars of tax debt in bankruptcy. Mostly, however, the debts we erase in Chapter 7 are the types of obligations just about all of us have, like credit cards and medical bills. These can potentially be eliminated for those who qualify for Chapter 7. Whether or not it's appropriate to consider a Chapter 7 bankruptcy filing can be examined with these three tests. Number one, as we've already addressed, you cannot own too much. You could have a car and personal property and bank accounts, and usually even owning a house isn't a problem. But your assets cannot be too valuable and must fit within the exemptions available under the law. Whether or not your assets fit within the exemptions is a matter to be discussed with an attorney. You cannot earn too much. That's number two. Chapter 7 is intended for people with relatively modest means. To meet the income test, it helps if household income is no more than the median income in your state for the size of your family. The income standards change every 6 months, and pretty much every day I'm reviewing median incomes with people like you. I should point out that I and every bankruptcy attorney I know provides free telephone or in-person consultations, so you have nothing to lose by learning whether or not it may be advisable or appropriate for you to consider a bankruptcy filing. To file a Chapter 7 case, you can't own too much, you can't earn too much, and number three, you cannot abuse your credit card debts or other debts. In this context, there's been abuse of credit cards. For example, if in the months leading up to the bankruptcy filing, the debtor went on a cruise, bought an 80-inch TV, or otherwise lived high in the hog at the expense of his or her creditors. I have met thousands of people over the past 30 years, and I can count on my fingers and toes the number of people who intentionally ran up debts in advance of a bankruptcy filing. It just doesn't happen very often. Most of us use our credit cards to buy food for our fridge, gas to get to work, and clothes for our kids. Very few of us have the time, energy, or inclination to intentionally run up our credit cards. Moreover, the vast majority of people are honest and hardworking and just trying to make ends meet, and having a pile of fun at the expense of our creditors never enters into our minds. Nonetheless, your attorney should have a detailed discussion with you regarding what credit card debts have been used for, and if you borrowed a personal loan, what the money was used for. With respect to medical bills, they are easily dischargeable in bankruptcy and easily deemed a necessary expense because no one gets a colonoscopy for fun. Let's presume that you qualify for Chapter 7 bankruptcy. Is that all that needs to be examined? No, it's not. There are options for resolving debt other than filing for bankruptcy, including utilizing an honest credit card counseling agency. Attorneys are ethically required to help you consider all options, including non-bankruptcy alternatives. But let's say you qualify for Chapter 7, and more importantly, an attorney you trust advises you that a bankruptcy filing is appropriate. What can you expect? A Chapter 7 case takes about 4 or 5 months start to finish, and if all goes well, the court will at the end of that time enter a discharge order indicating that your dischargeable debts have been eliminated. The discharge order is permitted to remain on your credit report for about 10 years, for exactly 10 years, which can sound scary. But when I sit down with the client, I give them a chart which shows them how quickly their credit can improve and how soon they could potentially obtain an auto loan or home mortgage at ordinary rates after a bankruptcy filing, presuming, of course, they keep their credit clean from that point on, and their income can support the installments. While the case is pending, there would be a meeting with the court-appointed trustee, and credit counseling and debt management sessions are required before and after the bankruptcy filings. These will be the subject of future videos, but can be easily explained by your attorney. That's all for now. Thank you for watching.